really the same sort of thing. So our company's awesome, yada, 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 and we have a whole bunch of different locations, and I'm thrilled to announce, I'm just going to stop on this for 1 second, that we're going to have a brand new location opening up January 1st. It's our first one in Loblaws, and it will be located at Argentia and Winston Churchill. So in Mississauga, we'll have we're starting up a relationship with Loblaws in addition to Walmart. So that's thrilling. All right. So the first thing that lawyers do to fight is figure out what the state of play is. And what I wish every agent would know is the basics of what a real estate transaction is. Now, let me start by saying that there is an assumption that is not right, that people who are going into a retail environment and buying a sweater, they assume that the sweater will be in a perfect state of order. They assume that they will not be frayed. They assume that there will not be one arm bigger than the other. And if it is, heaven help the salesperson who sells it, because you know exactly what people are going to do. They're going to go back and they're going to demand whatever it is. Now, this is a purchase. It's a purchase like a candy bar. It's a purchase like a sweater. And for most people, when they think of a purchase, they feel that they are entitled to a perfect sweater, right? But that's not the law of real estate. You guys know that that's not the law of real estate. And sometimes it's good to just kind of sit back and think about this for a minute and understand that the law of real estate is not one where things are perfect. It is in new construction, but it's not when it comes to resale. I am permitted to buy a car with rust. A car with rust still has value, right? It's not $0. You're going to sell me a rusty car, so they pay more than $0. I'm permitted to do it. And then if I buy that car with rust, can I then say, hey, by the way, this car has rust? I'm returning it to you? No, you knew about it. That was the object that I was buying, was an object with rust. Caveat emptor is the same thing. When you're buying a house, you are not buying a perfect house. You are not buying a house without problems. You are buying a house that is the way it exists at the time of sale. So you're not entitled to a new roof if they're 5 years old. You're not entitled to a new plumbing system or anything else. Now, all of this is obvious. You guys know this. You know that if your client were to call you up tomorrow and say, hey, by the way, my roof isn't new, you'd say, what are you talking about? You bought a house with an old roof, thank you very much. But that doesn't actually address the substance of what people are saying to you. Because when they come to you and they say, hey, by the way, the roof is 5 years old, they don't say to you, hey, the roof is 5 years old. They come along with the story. They come with the story. And that story is, hey, you know that basement that I bought? Well, it turns out that there's mold underneath the floorboards. I didn't see it. I didn't know about it. They sure knew about it. That doesn't seem fair. Yes, I'm buying what it is I thought was there, but they concealed it from me. They intentionally went ahead and put a carpet down on the floor, brand new, so that I wouldn't see or smell the mold. And suddenly at that point, the story has changed. So what they're saying is, I know about caveat emptor. I know that I'm buying a house, but they have done something to conceal the fact that this has a defect. Another story that comes along all the time is the story that says, hey, Mark, I knew that I was buying a basement that was old. But when I asked them specifically, have you had any flooding? They said no. And yet, I just found out from my insurance that 1 year ago they made a claim because of flooding in the basement. They made a misrepresentation. They made a statement of fact. I'm sorry, that was very rude. They made a statement of fact that induced me to enter into the contract. But that statement of fact turned out, in fact, to be inaccurate. What about the other story that happens? Hey, Mark, when we bought this house, there was no flooding in the basement. But 2 weeks ago, there was a flooding, and now the basement is not actually in a state of order. Well, those three things are probably the three most common items. We're going to get to number 4 in a second, which is point 3, part 2. I don't know why it doesn't say 4 there, but anyways. These three top things are the three most common complaints that we always get. And this can reverse caveat emptor. And this is part of how lawyers fight back. So part of the story that we are asking for from people, if they just say, I don't like the fact that the house is X, and they bought the house as X, do we have any play? Nothing. Nothing we can do. Done. Yeah.
What if the flooding on the basement occur just before closing?
So we're going to talk about that. We're actually going to talk about that in terms of the right to receive what you contracted for. Because there's an implied term in every contract that you're going to get what it is you paid for. And are you getting what you paid for if there is now a flood in the basement? That's substantially a different product than you had originally bought, right? Therefore, you're allowed to say, no, 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 no. I'm not going to get that. Thank you very much. I'm not going to buy. Now, in the case of a flood, that's an insurable risk. And pursuant to the Agreement of Purchase and Sale, there is something that deals with insurance. Section 12 of your normal Agreement of Purchase and Sale says that the seller shall, until the day of closing, maintain insurance for the benefit of the buyer, and the buyer can elect either to the insurance proceeds or to not complete the sale as they see fit in the event of a substantial loss at the property. Okay? So it's answered in the Agreement of Purchase and Sale. But say that wasn't there, I would still be able to object. And I would be able to object specifically because there is an implied right to receive in every contract what you have contracted for. And what I contracted for was a basement without a flood. And what I'm getting is a basement with a flood. And therefore, it is not the right implied contract. But it's superseded by the contractual terms that I've just described to you. Okay? So really what we're doing every single time someone comes to us with a complaint before closing about a problem with the property is we start with caveat emptor and we say, well, I'm sorry, client, you're SOL. You're just out of luck. Then they tell us the story and they say they've concealed or they made a misrepresentation or this property is substantially different than what I purchased. At which point, we suddenly have rights. We say, yes, caveat emptor is the law, but we know we can get around caveat emptor through these items. And of course, there is the last item, which is the one that you've all learned in your OREA courses, or whatever the devil it is that they're now, since now the organization is teaching you, I don't know. And that's latent defect. In the event that there is a defect that is known to the seller, which is not communicated to the buyer, which the buyer would not have ordinarily seen in a normal inspection, then case law says we can go after the seller for those damages. So to be clear, if there is a giant crack on the ceiling that the seller does not disclose to the buyer, that is not sufficient to claim latent defect. Why? It's not latent. It's patently obvious. Anyone who's buying looks up and sees it. A roof, patently obvious. It's expected that you will inspect the merchandise. No problem. What is a latent defect is something that just happened in our office 2 weeks ago, or 2 months ago, where someone literally went ahead and constructed a brand new wall to hide a crumbling foundational wall. They intentionally concealed, right? It's number one. But that's also a latent defect. It's a defect of which the seller was aware, that they did not communicate to the buyer. That is not visible upon reasonable inspection, because they specifically built a wall to stop it from being visible upon reasonable inspection. And as a result, in those instances, they get a nice letter from me saying, dear solicitor, be advised that there is a latent defect at this property. This defect was not visible, was known to your seller, and was not communicated to us. How do I know it was known to your seller? I know it was known to your seller because the drywall guy is the person who identified that they just built the wall there. That's actually what happened. Yeah?
Is it acceptable in the case that the lawyer doesn't bring an inspector?
Sure.
But if they bring an inspector,
Inspector does not get rid of that because the inspector is only going to see what is obvious anyways.
Oh, okay.
The inspector doesn't go behind walls or anything else. And remember, concealment, which is the case here, is something where they are ultimately concealing a defect, right? And you can get around it. even if you have an inspector. So what I want every agent to know is that caveat emptor is the law, and getting around those exceptions, getting around caveat emptor requires you to use one of these 4 exceptions. I know I have 3, but 4 exceptions that I've laid out. And I want you to understand that that's one of the ways that lawyers fight for the clients. Getting back to the actual topic that I'm theoretically supposed to be speaking about today. These 4 items are how we do it every time. This is what my legal brain is saying. So if someone comes in and says, Mark, is there a problem? They say, I have a problem. I say, great, tell me about the problem. And I go through a whole bunch of legal checklists and everything else, but primarily, I'm checking off whether or not there's concealment, negligent, fraudulent misrepresentation, right to receive, related defects. Now, just on this one point here, just before I move on to the next thing that I wish every agent would know, does anyone want to hazard a guess between innocent, negligent, or fraudulent misrepresentation, what the difference is? So these are statements of facts that induce someone to enter into a contract at the time the contract is being made. So an innocent misrepresentation, let's use the example of a school district. So if someone says, the question is, can I send my kids to this school? Is this school in this area? And someone has sent their kids to that school in that area. And they say, yes, you can. But unbeknownst to the seller, the school districts have changed since they sent their kid there. This is actually the case in our office. Is that an innocent, negligent, or fraudulent misrepresentation? Innocent. There's reason to say, yes, the school is in this area. I have sent my kid there for 12 years. I believe it. There's good reason to suspect that. It's not a negligent statement to say that. It's wrong, but it's not negligent. If someone asks you a question and says, hey, can I send my kid there? And you don't know the answer and you say yes, that's negligent, because would a reasonable person do that? And if you do know the answer, if you know that it's not the case and you say yes, then that's fraudulent. Anybody want to hazard a different why fraudulent is different than negligent?
You know that it's incorrect.
Right.
It's still, you're hiding the fact.
Correct. And as a result, in a court case, because fraud is criminal action, you have to go beyond balanced probabilities, right? It's different standards of proof. It's more than 50%. But the reason that fraudulent misrepresentation and judgments for fraud are so powerful is because fraud survives bankruptcy. And if you go bankrupt, fraud judgments continue after the fact. You can never escape a fraud judgment. Okay, so that's the first thing. Let's deal with the second item. Ways we can fight for our clients, and at the same time, things that I wish agents would know. And specifically, I'd like to talk about how deposits work, because they are a functional problem that you're going to encounter if you're an agent that does any sort of deals regularly. Deposits not paid in time cancel a contract. So a normal agreement of purchase and sale says that time shall in all respects be of essence and that they must complete a contract. Now this is something that causes concern because for many, many years it was the case that if you didn't provide a deposit in time, then there was no harm, no foul. There was an argument to be made that the purpose of a contract was the payment of X for Y. What was X? What's X? Money for property. Not deposit. That wasn't the purpose of that. Money for transfer. Now, you have to understand, in order for me to explain what the controversy here is, so that we're clear on this when we leave the room, how law works. And I think I've used this description before in this very room, but I'm going to do it one more time. So if I am a guy, I like this description when I used it last time, so I'm going to use it again, because the second time using it in my life, the second time in this room. If I'm a guy who walks into a car dealership, and if I come in all haggard and distraught with 6 kids in tow, and I walk into that used car dealership and I'm like, minivan, I need a minivan, and they say, all right, sir, what type of minivan do you want? You're like, I don't care. I need to take these kids to hockey practice. It needs to have a big trunk, big trunk, big trunk. All I care about is a big trunk, big trunk. They're like, all right, fine. Here's a big trunk minivan. And you're like, all right, this is great. They're like, all right, sir. And last detail while you sign this contract, what color do you want? You're like, I don't care. It has a big trunk? Fine. Green, red, sir. Green. And then 3 weeks later, the minivan comes in as red. Does that cancel the contract? No. Now, did they live up to the contract? They did not. And so if this were to go to court, a judge would then say, okay, how important was that color choice? Well, not very important. We'll give damages. We'll give money, but the contract is still in force. Now, let's say I was not that same person. Let's say I was that smarmy idiot down in Yorkville who walks into the Maserati dealership and says, I want a red Maserati and a green one is delivered. And I go to court. And again, going to court over a car and a color that was different. Will the judge then say damages are sufficient? Probably not. The judge will probably say, no, 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 this goes to the heart of the contract. A red Maserati matters. It matters. We all understand why it matters. We understand the people who drive red Maseratis and why they want red. And if green comes, that's not acceptable. That's not what they were contracting for. And so there is a difference between the degree to which items of a contract are important. This is called the difference between a condition and a warranty in law. And so for many years, it was believed that the deposit was a warranty. That is to say, was only a portion. The contract would still be alive if the deposit wasn't given in time. That was the belief. Because it was believed that for a long time, it was similar to a green minivan, not a green Maserati. But case law has changed it. Since 2005, it has been clear that our courts are now saying that deposits not paid in time are in fact fatal to the contract. So if you do not get your contract there, your deposits in the time stipulated in the agreement, there is Ontario-based case law that says, thank you very much, the agreement is at an end. Now don't get me wrong. You still, in most cases, if the other side says, no, it's not, have to go to court to get this order. That's why what every agent needs to know is that they should have a clause in your Schedule A that says this agreement is conditional upon certified funds being provided as the deposit within 48 hours of acceptance of this agreement, failing which the agreement shall be null and void. Everyone should be including that in Schedule A. Why? It's not because that's not already the law. It is. But you don't want to have to go to court to prove it. And it's not part of our... So even though that is the law in Ontario, if it's not paid, thank you very much. You don't want to have to hire a lawyer to get a judge to order that. So in an effort to actually make sure that things are good, you want to actually, I don't know that this is worded right, I did it very quickly on the plane last night, but you want to say the agreement is conditional upon certified funds being acquired within 48 hours, failing which is null and void. Why? Because that way, if they are not given within 48 hours, your lawyer will send you a letter saying, you are fine to go. Please go ahead and relist. You're good. And then you don't have any worries about it. Yeah?
So, I noticed you don't say banking days or whatever, it's 48 hours. So really as an agent, I should bring, it doesn't necessarily have to be certified, just a check, so I'll replace it with a certified check on Monday morning. If it's,
I do say certified funds.
No, but I mean, like as an agent, I should say maybe, I'll give you this check today. I know it's a holiday weekend, Monday the bank's closed. On Tuesday, I'll bring in the certified replacement check. Or what's the best practice for that?
So, okay, so first of all, let's talk about what, so there's always confusion about days. There used to be something called the Days Act in Ontario that stipulated what a day was. There is no longer any such legislation. It's been repealed. And it doesn't help to say banking days anymore because banks are open 7 days a week. So days mean days. Plain and simple. If you see days, don't play any game. Day is a day. Business day should be defined in your contract. It should be business days, defined as no Saturdays, Sundays, or statutory holidays. It should say that. When I say 48 hours, I mean 48 hours. In this case, if that's the case, and someone says, hey, I can bring you a check, and then I'll replace it, then you want to go ahead and codify that via email. So let's say you're acting for the buyer, right, okay, and not the seller. And this clause is there. You don't want to strike the clause because you're trying to get a deal, and this is ancillary to that. We don't want to be legal when we're trying to arrange our deal. We understand, we just didn't get the deal. So you sign the deal, and now suddenly you realize you have this problem. So what you want to do is you want to write to the agent, and you want to say to them, I am going to get you the check for this day, is that okay? And the moment they say yes, you are fine. The reason being, I'm just going to explain, I'm here as a lawyer, so I might as well just talk law for a second. The reason being a concept called estoppel, E-S-T-O-P-P-E-L. And what estoppel says is even if you have rights in a contract, you are denied from enforcing those rights based on your conduct. So a good case that I had to deal with was a contract. I dealt with a shampoo distributor for all these salons. And there was this product coming out called Moroccan oil. And all these salons wanted this Moroccan oil thing. I don't know, maybe you guys are familiar with it. But, so we had a contract that said, we are going to deliver this by the 16th. And they wrote us an email and they said, hey, by the way, don't worry, you can deliver it by the 18th. We delivered it on the 17th. Then they sued us. This was for millions of dollars. They're a big salon distribution company. They sued us. And we went to court and we said, no. Yes, you have a contract that says we are to deliver by the 16th. But you are stopped from relying on that contract because of your conduct. And in this case, your conduct was an email that said it's fine to deliver on the 17th, 18th. On the 18th, whatever, sure, yeah, okay, sorry, yeah. I was actually thinking about the dates. I don't remember. The story is correct, but the dates I was kind of fucking at. So to answer your question, if you're not able to make it, as long as you have the agent verifying that it is okay, then they are stopped from relying on that provision in any event, and you'll be fine at law. You'll be able to enforce.
Just to follow up, the agent's okay, so it doesn't have to go to the client.
No, it does not, because the agent, pursuant to Section 3 of your agreement, the notice provision, is entitled to act on the behalf of the client, and is entitled to sign on their behalf too. So that's not a problem. The client is necessarily indemnifying the agent. This is the law of agency. It's the whole purpose of an agent. So long as you hear from the agent or the brokerage through their agent that it is acceptable, don't get me wrong, they may still try to fight you, but if it goes to court, you will win.
Is this a verbal or written?
Written. Nothing is verbal, ever. Anything that is verbal, you follow up with a nice email saying thank you very much. You don't say pursuant to our conversation or anything else, because the moment you sound like a jackass lawyer, people treat you like a jackass lawyer, and then you get no deals, right? So the last thing you want to do is be a jackass lawyer. But that doesn't mean you can't follow up with your own deal. You can say, Jack, so great that we did the deal together. I'm looking forward to seeing you at the Christmas party. Whatever it is, yada, 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 yada. Thanks so much for the indulgence of allowing me to bring in my deposit within 72 hours as opposed. That's really going to help out my client, and he's very relieved to hear it. Wishing you and your wife a wonderful, wonderful Christmas. Thank you very much, done. And you've done the exact same thing, but you haven't been a jackass, and it means to go do more deals. You can still be legal. You don't need to be legal sounding. Don't be legal sounding, ever.
Excuse me, Mark.
Yeah.
So in the original agreement of purchase and sale,
Yeah.
so regarding deposit, when it says like, if we don't add these clauses, okay, here it says like 24 hours.
It says 24 hours, but it doesn't say null and void.
Yes.
So the reason that we put in this clause is because this specifically says if you don't bring it in within 24 hours, it's null and void.
I mean that if they don't put these clauses, and if they don't bring the deposit in 24 hours, the deal is.
The deal would still be, you are allowed to go to court.
Oh.
So you can turn to them and say, thank you very much, the deal's at an end. Then you're going to get a lawyer's letter back saying, no, it's not. This is, and remember we just talked about the difference between a condition and a warranty in law. They'll say, this wasn't fundamental to the contract. We gave you your thing. You're not able to do this. You accepted this. Done. But if it's written the way I've written it, then it's very clear and definitive, and it just avoids the problem. So it's not that you're not right in law. It's that there's a difference between being right in law and having to go to court to prove it. This makes it easier to not have to go to court.
Yeah.
Which is our goal overall, because again, we don't want to be jackass lawyers.
But in that case, so they have to.
They still have to bring it. They must bring it within the time period specified, because if you take a look in the last part of your agreement of purchase and sale, it says time shall in all essences hereof, provided that time for doing something or completing any matter shall be of the essence. What we're saying is time is a Maserati. Time is not a minivan. Okay? That's what we're saying. That's why that clause is there. Okay, makes sense? Any other questions on that before I keep on? All right. So let me bring this back to the topic that we're discussing today, because again, the topic is how do we fight? Well, we fight because if you haven't brought in a deposit, or if the deposit is being delayed, which happens quite often, you say, hey, here's the case law, you're in breach. I'm going to extend 3 more hours, get me my deposit. Or alternatively, if the clients want out, we can get them out. Done. Okay. Now let's talk about the deposit further. There is confusion. This is actually one of the prime ways lawyers fight. And I'm going to give you guys the little secret that you need to know that you are missing from your experience, however vast it may be. There's one thing I'm going to tell you from this, which will contextualize how you're going to act every time there's now a breach filed in your deal. So, what happens to deposits when a deal goes south? What happens? Well, the answer is, previously, deposits didn't necessarily, there's nothing that stipulates what's going to happen to the deposit in the agreement of purchase and sale. Let me start there. Further, the agents have no claim on the deposits. This is between the buyer and the seller purely. Don't get me wrong, the agents can make claim on their own clients. They can, separately. But we're talking about a deposit that the buyer has given the seller in trust, being held in trust by the brokerage. And the question is, my deal has terminated, am I entitled to the deposit? Now several years ago, the law on that was that of Asamara, which was the name of the case. And Asamara said that you have a duty to mitigate your damage. You have a duty to go ahead and resell your property, and if you resell your property for more money than you would have gotten, plus your damages and everything else, you are not entitled to anything else. That's it. That's what you're entitled to. But in 2013, and it was affirmed in the Ontario Supreme Court as well, there is new case law that says the deposit is liquid damages, period. So no matter what you sell for, if you resell for $200,000 more, you are still entitled to the deposits as damage. That's the law now in Ontario. Now, they say it has to be a reasonable amount. Reasonable being defined as about 10% of the purchase price. Roughly, that's what courts have said in there. It's called obiter dicta. That's their ramblings. But that is what it says. But that is what goes on with the deposit. Now, that's all well and good. So we now understand that the law in Ontario is, thank you very much, I get my deposit, it'll have law. But let's now combine that knowledge with REBA, because this is where it's going to become interesting to you. REBA under Section 27 says that a brokerage, which is usually the place where a deposit is held, can only release deposits in one of 3 instances. 1 is on completion, 2 is upon mutual release, and 3 is a court order. And as a result, if, in fact, there is no mutual release, you have to go to court. And here is where the breakdown in knowledge takes place in an agent's brain. Because they may know Section 27.1, and they may know that they have to get a mutual release. But what's missing from their knowledge is how much does it cost to go to court. Because if what you're trying to do is figure out whether or not you should be negotiating out a mutual release or going to court, you cannot do that without an understanding of how much it is to go to court. And the answer is, if all you're doing is getting the return of the deposit from court, not suing for damages or anything else, that's a statement of claim. So there's different ways of going about court actions. You can begin an originating process, which is called a statement of claim. And that's the trial that you're used to, right? And if you're going for major damages above $25,000, that could be a 2-year process. It can involve $50,000 in legal fees, discoveries. It's a huge thing. Whereas you are able, if all you want to do is get the return of the deposit pursuant to Tang v. Zhang, you can bring an application under Section 3.1 of the Vendor and Purchasers Act. And that application costs between $5,000 and $10,000. Now that is a critical thing to know, because if there is $50,000 being held in trust, you should not be negotiating for anything other than $40,000 back to my client and $10,000 to them. Not let's divide it 50-50. Why? Because you now know that it's going to cost $10,000 in court fees to get back the return of that money. That is a critical component to understand. So if all you're doing is looking for the deposit, and if you have an idiot agent on the other end or an idiot buyer who's ultimately refusing to sign a mutual release, then you should be willing to negotiate money back to the buyer equal to approximately $10,000 and not a cent more. Anything else goes to a lawyer, because in 2 months the lawyer will bring an application under the Vendor Purchasers Act and get that money returned minus perhaps about $10,000 in fees. Now you have what you need in order to properly judge what you're going to do when these deals fall apart. Does that make sense? Remember, that's not the cost of a statement of claim. That's the cost of an application for the return of a deposit, which is different. You're allowed to pick both of your routes.
It has to be submitted where?
What?
The application.
No, an application is a court process. Application means that you're able to bring an action to the court for the return of the deposit. So,
and the time frame?
Generally, what we say to clients, 3 months. What it actually is usually about 6 to 8 weeks. 6 to 8 weeks. But say 3 months just to be safe. Be done. Okay. So now that's actually really good knowledge. So what do we do as lawyers? Let's bring it back to what it is I'm theoretically supposed to be talking about, because again, I've amended the conversation a bit. So how do we fight? Well, we fight knowing these costs. So the first thing I do is I throw Tang and Zhang and say, thank you very much. Your deposit is mine. We know it's mine. You have no grounds whatsoever as Samara. The ability to mitigate damage doesn't apply here. What's more, you know very well that it's going to cost us $10,000 to bring our application. Here's the Vendor Purchasers Act. So you better agree to this, or else we go to court, because you're not getting this money back. And then they either agree or don't, but I don't care. Right? I really don't care. I make $10,000. I mean, at that point, I'm just smiling. Right? From my perspective, that's phenomenal. But there it is. And by the way, it's usually not $10,000. I say $5,000 to $10,000. It's actually usually closer to $5,000. I throw $10,000 in there in case that they throw a motion or something else that needs to be make its own way. Make sense? All right. Item 3. Yes.
Let me go back to the deposit. This scenario that many agents are under assumption that, okay, if we don't bring the deposit at a time, if the buyer want to get out of the deal just before even put the deposit, they say, oh, if there's no deposit there, the deal is basically canceled. But in fact,
so it depends. If you have my clause in here, then the deal is canceled, which is actually what I want, because if it's 24 hours into a relationship and it's already going that route, I have made a decision in my own mind that I would just the parties divorce and not have anything more to do with each other. If you have the normal terms of the agreement of purchase and sale, if you don't put that in, then the seller can theoretically go after the buyer till the ends of the earth. That you don't bring in a deposit doesn't mean that there's no deal. It just means that you've breached the agreement. But the seller is able to still maintain that they want to close, and they can sue you for all the damages. The reason that you want this clause is because it's advantageous for the seller as much as the buyer as well. Sure, the seller is giving up their right to sue the buyer. That is true. But that's only after 24 hours anyway, so it's not a big relationship. But also, the buyer might have a claim on the seller to say, yeah, the contract is still in force, even though I didn't abide by the deposit. And then the seller is roped into a worse situation. And so on balance, you have to balance, do you want to have a nebulous thing where the contract parties are still tied together even though the buyer couldn't do the menial task of bringing the deposit that they promised 1 minute after they signed it? Or do you wish that everyone just go their own separate ways so that we can properly service the seller and get them to a state of work? That's the reason I opt for this. this. I didn't go into it in great detail, but on balance, those are all the decisions that go into including that clause. But I'm sure you'll agree, it's just better to have that clause, given that if you're failing within 24 hours, just divorce yourself and be done.
And still we need mutual release in case of having this.
You should always have a mutual release, just because it covers you. You don't need a mutual release, no. But you should get a mutual release anyways. What you would get in this case, maybe not a mutual release. If you don't get a mutual release, you'd write to the lawyer and say, hey, lawyer, give me on your letterhead that I can relist, please. And why do you care what the lawyer has to say about that? It's not because these lawyers are brilliant. Hell, real estate lawyers are probably the bottom of the barrel when it comes to our profession. We all know it's true. Why do you care what the lawyer has to say? What makes me different than you?
It's 3 years of legal school.
No, it's not 3 years of legal school. No one cares about that. You learn nothing in that. I learned how to
No
drink.
liabilities from the life short.
That's right, because I have insurance. It's because when I write that letter, I have insurance. And therefore, you can say you were competent, you were following the lawyer's instructions, no one can sue you. You can sue me, and I have an insurance policy. By the way, as an aside, anyone who's dealing with other lawyers, this is my subtle way of telling you to use Access Law. Anyone who is dealing with lawyers should understand that there have been changes in the insurance of lawyers. Lawyers are now only covered for a laughable $250,000 per real estate error, unless they have excess insurance. So you should be inquiring of any lawyer you go to, do you have excess insurance? And you should not be dealing with anyone that doesn't. We have $9 million worth of excess insurance. We do not go to real estate lawyers if they do not have excess insurance. There's a coverage of $250,000 when homes are worth 1.5 is just pointless. It's just pointless. And most lawyers don't realize that that's the limit of their insurance because it used to be $1 million. Yeah.
So if say you have a condition and the buyer is not satisfied with the condition, would you still need a mutual release at that point? Yes.
So sorry, can you repeat that? I apologize.
So there's a condition, both parties accept, and then come the time to either fulfill waiver, not fulfill the condition, the buyer's not satisfied with their home.
No, you don't need one. Your
Okay.
brokerage is going to insist on one.
Okay.
But if you just go to a lawyer and say, can I relist? A lawyer will look at that and say, okay, you're telling me that there was no fulfillment of condition, fine, you can relist.
And on the buyer's end, like
Same thing.
same thing. They
Same thing. A lawyer will give you your out as well. If they don't, I always write letters like saying, okay, you're telling me that they're not signing a mutual release for some reason, but they didn't fulfill a condition. All right, my legal opinion is that you are fine relisting.
Okay.
Put it on my shoulders. We're done.
Okay.
Yeah.
So I might just follow up. So my understanding, what you just said, is there's only 3 ways deposits can be released. If the deal closes, the mutual release is the court order. So I think what you were asking is, if there's a home inspection it doesn't work out, then the only way to get a deposit back, I understand, is through mutual release, not through, but Jerry said a lawyer will suffice.
Sorry, the only way to get the deposit back is through a mutual release or a court order.
Right. Okay, good.
It's not through a lawyer.
Okay,
Okay.
yeah.
Sorry,
So-
I misunderstood the question then.
Okay, so
Sorry.
yeah, so the buyer would then still have to ask for mutual for the
Mutual
seller
release
to
or,
sign
and I'll tell you we actually have, we have built a huge business, or we started our business in Brampton. There were tons and tons and tons of people who were insulted that people were walking away for financing or home inspection and just refusing to sign a mutual release. So we were bringing this application over and over and over and over again. We love this application, because this application is literally the same set of facts with the same core constituent document with the same, there's no question as to what happened. It's just you go before a judge and you're done. And they look at you and they're like, you're here again? We're like, yeah. And they're like, all right, there you go. And it's fantastic. All right, so that kind of concludes the section that I'm theoretically supposed to be talking about. But I kind of wish that I had presented to Marty what the real topic of this conversation is, which is what I wish agents would know. So with your permission, I'm just going to continue down that vein, because I think this will be very useful for you going forward. Because what I really wish agents would know is taxation. I really, really, really wish agents knew taxation. And I'm going to, with your permission, I know I only have 10 more minutes, go over those issues that are most pertinent in taxation that agents have trouble with. Forgive me, I'm just kind of transferring what I'm supposed to be talking about to something slightly more aggressive. So first of all, HST. I know each and every one of you shudders when that HST thing says included in or excluded from. Not because you don't understand what included in is and what the excluded from is. In fact, when they ask you about HST, you always try to explain exactly what included in and excluded from is, because that's the extent of your knowledge of HST. And I'm not blaming you for it. You're agents. Every single person is the same bunch. I haven't canvassed you. I know that this is the case because this is the way agents out in the field work. But what you don't understand is how HST actually works with regards to real estate. So let's talk about it. Permit me. Sorry if someone does know how this works, but let me go into it. HST is not applicable on residential surplus. That is a term in the Income Tax Act. What that means is one unit in a house where someone is living is residential surplus. A duplex is residential surplus. A triplex is residential surplus. A quadplex is residential surplus. You know those giant buildings that have 100 units in it? Residential surplus. If you go ahead and buy that building for $18 million, there is no HST on that giant building, provided the only purpose to the unit is to accommodate residential living. No matter how many people are there, it is exempt from HST. So it doesn't matter if you say HST is included in or excluded from on a residential surplus property, because there is no HST payable, period. So that's the first thing.
Even if it was for investment purposes?
It doesn't matter. Residential surplus pertains to what the property is being used for, provided that it is used to accommodate residential living, not commercial activity. You are fine. Okay? So what about commercial? What about everything else? Well, this flips an agent out the first time they deal with a commercial deal. Because the first thing they see is that HST is not included in, and not even an option on the Form 500. It's just, it's excluded from. You have to pay HST in addition. But what is not known by agents, what I wish every agent would know, if you will, is that HST is zeroed out. Now, I don't need to go into what that means. Suffice it to say, if both the seller and the purchaser have HST numbers, which everyone usually does, and certainly the seller will if it's an income-generating property, because they've been making more than $30,000 a year. And certainly the purchaser will. You'll just go out and get an HST number if they don't have it. Provided they both have HST numbers, they don't need to pay it. And I don't need to describe why or how or anything else. Suffice it to say, even if HST is payable, it will not be paid. It is a freebie from the government because they understand that it's a huge cash flow issue. There's a different way of doing it. It's called zeroing it out. And so HST practically does not present an actual obstacle to you ever. Ever. Because whether HST is exempt because it's residential surplus or is included but then zeroed out, you are fine. Does that make sense? Okay.
So how do we fill out the HST?
Always say HST is included in,
Okay.
right, for residential, because the buyer will have some security. And for commercial, your forms automatically choose not included in. I forget how they say it. Excluded from, whatever. Yeah.
Sorry, so I was dealing with live work loft, and so 2/3 was live, 1/3 they were work downtown. So you had to put the amount in of 1/3 of the HST, but it is a wash thing.
It is a wash.
Yeah.
You're right. You would still have to, and you would say is in addition to, is what you would say there. But practically, what I wish every agent would know is that the actual money is not paid on closing, meaning that the purchaser can breathe a sigh of relief knowing that they're not going to have to take 1/3 of the property value and add 13% to that, right? Which is the critical component. Because they don't care if HST is there or not, because it becomes an input tax credit. What they care about is whether they'll have to pay it, because that means they have to assemble it, and which is something that they cannot do. Okay, municipal tax. I wish every agent would know how to calculate damn municipal tax. It's not hard. This is not hard.
There's calculators for it.
No, forget about calculators, because sometimes there aren't. That's only for certain jurisdictions. All you need to do is take your MPAC assessed value, which is in your public records. You know, the public records little tab on the left-hand side of MLS. Go to public records, type in your property, it will give you your assessed value. You take that assessed value and you multiply it by what's called the mill rate, M-I-L-L rate. That gives you your tax payable per year. So in Ontario, in Toronto, the present mill rate is 0.0068 something. So all you do is you take your assessed value of $1.2 trillion, because that's what Toronto real estate is, multiply it by the mill rate of 0.0068. Bob's your uncle. There's your taxes. And you can independently verify, as against MLS, whether or not the taxes that they have up there are real. Make sense? All right. Capital gains versus income tax. I wish every agent's eyes would not cloud over when it comes. You don't need to take pictures. I'm happy to send you the presentation. Like, the whole thing is yours. As long as you forgive the fact that it says 3 twice on that first page. I wish everyone would actually know what the difference is between capital gains and income tax. Okay, and I'm just going to go over it very quickly. In the event that I purchase a property for $100,000 and I sell it for $200,000, the amount of money that I've made is $100,000. If it's income tax, that $100,000 then gets included as part of my income. Let's say my income is the top tax bracket, which is now 54% in Ontario. That means $54,000 of that $100,000 goes to the government. Used to be 43%, by the way. Now it's 54. Anyways, that means that $54,000 goes to the government. Whereas, if I buy a property for $100,000 and sell it for $200,000, and it is capital gains, then only 50% of that being $50,000, goes into my income at 54%. And therefore, I pay 54% of $50,000. And as a result, everyone wants to ultimately figure out if they have a capital gain or if they have an income tax payable. And I know that everyone believes that when they sell property that it is a capital gain, but the CRA believes otherwise. And the CRA is often saying, no, you bought this property with the intention of selling it. That is how you intended to make profit. Therefore, it's income. And this is the big discussion with the CRA. You see, who's been to Chudley's Apple Farm? No? No one's been to Chudley's Apple Farm? Well, if you had, I would say congratulations to surviving the experience and the pesticides. It's quite amazing. But Chudley's Apple Farm is basically a giant farm that's out there, and you basically go and land on a tractor, you get sprayed with pesticide, and you buy apples. When Chudley's decides to close up shop and cuts down their trees, they sell those trees for $100,000. Is that a capital gain or is that income tax? The trees. So when they sell the apple, is that income tax or capital gain? Income, because their whole business is designed around selling apples. When they cut down the trees that produce the apples, that is selling the capital asset that creates the income. Therefore, they have to pay 50% of that. This is different than a Christmas tree farm. Even though you're still cutting down trees and selling trees, they will have to pay income tax on those trees, because the whole purpose of that farm is to grow Christmas trees, right? So even though you're doing the exact same thing, you're being taxed differently. And the CRA's mandate is to figure out what you had intended to do with the property. This is particularly relevant in the purposes of new construction, where people are flipping properties, and they've always intended to flip properties. They were buying the property not to live, they were buying the property because they thought it would go up in value and therefore sell. And if the CRA can prove that, then not only do they nail you for HST for being a developer, I don't even need to go into that, but they will also then claim, hey, you are not entitled to the HST rebate, yada yada, but it's also income tax. It's not even capital gains. You always intended to do this. This was a business for you. Thank you very much. 100% of this goes into capital tax. Of the profit. Of the profit. CRA is not your friend. Okay, withholding tax. Now this is the thing on your agreement of purchase and sale that says that, I don't know why we can't speak English as lawyers, but it says you are not a non-resident of Canada. If you are a non-resident of Canada, that is to say if you're a foreigner, then the buyer has an obligation to withhold 25% of the purchase price. Don't worry, you don't need to do anything as agents for this. Nothing, zero, zilch. You just need to know that the lawyer is going to do this. And as a result, if someone says, hey, I'm a foreign buyer, foreign seller, I live in Iran or I live wherever it is, then you need to tell your lawyer quickly, because your lawyer knows that they may not be able to pay off the mortgage on the property because they know 25% is going to be withheld unless they deal with the CRA in advance of the sale. Does that make sense? Yeah?
I haven't heard this.
I'm not making it up. I promise you it's written. What it is if you are a non-resident for tax purposes, note this has nothing to do with immigration, this has to do with whether you pay Canadian tax. If you're a non-resident for tax purposes and you are selling a property, the buyer must withhold 25% of the purchase price and remit it to the federal government. Why? I'll explain it. So let's say you buy a property for $0. Let's say you sell it for $100,000. That is $100,000 worth of profit, right? 50% of that is included as capital gains. And when the tax rate is roughly 50% for most people, usually less than that, which means that 50% of 50% is 25%. So if you take 25% from the buyer and remit it to the federal government, then the federal government knows that whenever the capital gains payable, it has its money. And it will force the seller, even if they're non-resident, to file Canadian taxes to get its refund. See how that works? I'd say it's brilliant, but it's just evil.
What if you happen, like, you're not aware of that something closes, and then the CRA, would the CRA ever come after the buyers?
The CRA cannot, so the CRA cannot come after the buyer. Oh, sorry. The CRA can come after the buyers. The CRA has come after the buyers in one of my cases, and they called me up, they screamed, and they yelled, and I said, hold on, you have no issue. Because the CRA's rules are that as long as we have a statutory signature from the sellers stating that they are residents of Canada, which we have, then the CRA, then that's an absolute bar for the CRA going to the buyer. All the buyer needs to get is a statutory signature stating that they are residents of Canada. That's it.
And who would be responsible?
And then the seller has lied, then the CRA will sue the sellers.
Okay.
That's the CRA's deal with the sellers.
Who's responsible for getting that?
Buyer.
The buyer?
Buyer's lawyer, sorry.
Buyer's lawyer. Okay, okay.
So the buyer would be responsible to the CRA, and then they would go ahead and they would sue their lawyer. Then they would find out that their lawyer only has $250,000 worth of insurance, and they'd be incredibly pissed off. All right.
Okay.
What I wish, we're really running, I'm a bit late, guys. I don't want me to keep you. We're 5 minutes past time. Let's see how much more do I have. Oh, last slide, so let's do it. Last one, recapture. What I wish everyone would know, look, you're going to eventually have someone, you probably have 6 of them, who come up to you in like this underhanded way and say, by the way, I have millions of dollars to invest in real estate. At which point, by the way, instead of getting really excited, you should sit them down, pat them on the head, and say, you and everyone else, thank you very much, money is useless within the low interest rate environment. Tell me when you have something to sell. But, assuming that you want to engage with sellers and convince them to buy, sellers are saying, I don't want to sell. Why are they saying they don't want to sell? Well, firstly, they're going to have to pay capital gains. Secondly, money is useless. What are you going to do with money when you're in a 3% environment and you can't buy your assets? You're better off keeping it. But thirdly, there is recapture. Recapture is the gift the government gives you every single year, which is a gift that most people don't realize you have to repay. So if I go ahead and I purchase a property for $1 million in year 1, and then I allocate the values, the building value is $800,000, meaning that the land value is $200,000. I am allowed to depreciate that asset, forget about the first year, just assume that there's no such thing as a half year. I'm allowed to depreciate the value of that asset at 4% per year. Meaning that if I go ahead and have income of $60,000 per year, ordinarily I'd have to pay $60,000 into my income stream, 54%. But I don't. I only have to put $28,000 into my income stream. Why? Because I'm able to depreciate every single year as against the $800,000. So in year 1, I can get $32,000 worth of depreciation. In year 2, I get $30,000. Why? Because I don't have $800,000 anymore. I have $800,000 minus 32. I've depreciated that. Okay? And so on and so forth. And I can keep on taking 4% per year, over and over and over and over again. But here's the thing. When you sell your property for more than $1 million, it means that you shouldn't have been depreciating. It means that the value of the land hasn't been going down. And it means the government wants its money back. And all of those savings that you've had every single year, boom, 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 all of those savings have to be paid back. Okay? And as a result, what we're talking about with someone you're trying to convince someone to sell is not only to pay capital gains, but also to pay recapture. And that is a proverbial bother. I'm going to call it a bother. And what I wish every agent knew is that understanding that the tax paid on a property will determine a seller's willingness to sell. So I know I kind of deviated in the last bit with taxes and just talked a bit about taxes, which really isn't how we find it. The first beginning part was what the lawyer does when they do wrong, and I did it in the context of what I wish every agent would know, particularly pertaining to the deposits and your latent defects. That's it. I'm available for questions. Yeah, thanks for coming up.
Thank you. I have a question about, it's not related to it, it's related to non-resident tax.
Okay.
Can I ask my question?
Yeah.
I have a friend and he's a student here at the York University for 4 years.
Yeah.
So it's going to start January 1st.
Yeah.
But he came here in November. He wants to buy a property like a condo. And I know he needs to pay a 50% as a non-resident tax, but will this tax be refundable?
Yes. So you're talking about the NRST tax. And the NRST tax says that if you are part of an Ontario accredited institution, I believe it says, if you're part of, this is still a new law, but so I have to just remind myself, but I believe it says that if you're part of an Ontario registered institution, then yes, you are allowed to apply back to get the money back. So yes, the answer to that is yes, but in order to rely on that, send me an email, and then I'll put it in writing to you after I've done my research just to verify. Just because it's a new tax, I want to verify, but my recollection is exactly that.
Is there any time frame for that? If they want
I believe they have to get it back within 18 months or something, 24 months. I'll have to look it up. Sorry.
So I'm going to send it.
Yeah, just send me an email. What else? No, that's it. All right, so like always, guys, we have a Royal LePage hotline. Feel free to call it any time. It always goes to a lawyer that is on duty. Anytime that we're open, which is 7 days a week till 8 p.m., you can call, and we'd be happy to help. And that is that. Thank you.